All right, let's continue. Motion in Limine number 13 to preclude Lively from offering improper lay opinion. Lively's deposition designations and exhibit list indicate that she plans to offer improper lay opinion in at least three areas. One, to show that other people thought defendant's conduct was inappropriate. Number two, to show that other people thought Lively's cut of the movie was good. How is that even relevant? Okay, whatever. And number three, to show that other people believed Lively had a good character. Okay? What a waste of the jury's time, man. These lay opinions should be excluded under Rule 701, and much of this evidence is also inadmissible under Rules 401, 402, 403, and 404. A. Lively should be barred from offering lay opinion that other people believe defendant's conduct was improper. Lively should be precluded from offering evidence that other people believe defendant's conduct was improper. For example, Lively designated Alex Sachs' testimony that blah blah blah. Lively also designated Sachs' testimony that it blah 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 blah. What is this? Redaction after redaction. Oh my gosh, whatever. Lively also designated Sachs' testimony that it was blah blah blah. Significantly, Sachs was not present for any of these incidents. Why is this redacted? Is this not in the grade on sealing? Was this not added to the grade on sealing? Significantly, Sachs was not present for any of these incidents. There are numerous other similar examples. Lively has designated the testimony of Warren Zabala, in which Zabala, addressing a hypothetical, opines that redacted. Lively has designated a message chain dated blah blah blah, and the list goes on. None of this evidence is admissible, and no similar lay opinion should be permitted from the witness stand. Rule 701 permits lay testimony in the form of an opinion only if it's A. rationally based on the witness's perception, and B. helpful to clearly understand the witness's testimony or to determining a fact in issue, and C. not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. Federal Rules of Evidence 701, Lively's proposed use of lay opinion on the inappropriateness of defendant's conduct flunks each requirement. First, most of the proposed lay opinion is not based on the witness's perception. The rationale for the admission of lay opinion is the recognition that lay witnesses often have difficulties describing factual situations in language that is not that of an opinion, and that many factual situations that people observe cannot be adequately described in words confined to descriptions of observable phenomena. Explaining that an example of proper lay opinion would be testimony by an observer that a particular participant in a drug deal was different was directing the transaction, but none of the opinions cited above, except arguably some of the messages from Jenny Slate, relate to incidents that the witness themselves observed. Rather, they are naked attempts to put before the jury their opinions about incidents in which they were not directly involved. Second, even assuming the witnesses were opining on incidents that they themselves witnessed, the opinions would not be helpful to the jury. Rule 701 says that helps protect against admission of opinions which would merely tell the jury what result to reach, rather than providing information that would assist the jury in forming their own conclusions. And then there's another example, Village of Freeport versus Varela, vacating judgment in employment discrimination case where witnesses were improperly permitted to offer lay opinion on mayors' motivations for personnel decisions. Attempts to introduce meaningless assertions which amount to little more than choosing up sides should be excluded for lack of helpfulness. Moreover, the likely benefits of lay opinion testimony must outweigh its costs, and the costs of lay opinion increases and the benefits diminish the closer the opinion approaches the crucial issues in the case. The harassment claims are no longer in the case, and to the extent this lay opinion bears on whether Lively had a good faith basis to believe that she was opposing illegal harassment, the opinions of various participants that defendant's conduct was blank does not help the jury understand the testimony, but simply tells the jury what result to reach. Oh, this is such a good argument. I'm sure that they're going to get this one. Anyway, third, the reason Lively is offering the supposed lay opinions is not to illustrate the factual perceptions of an everyday observer, but to convey the opinions of witnesses with specialized knowledge and experience in the movie industry. If an opinion rests in any way upon scientific, technical, or other specialized knowledge, its admissibility must be determined by reference to Rule 702, not Rule 701. Lively doesn't want Saxe's testimony as a layperson. She wants her perspective as an experienced movie producer. The same goes for the testimony of Warren Zabala, the WME agent, about what comments are or are not appropriate as between a producer, director, and actor. Lively isn't interested in the opinion of Warren Zabala, man on the street. She wants the opinion of Warren Zabala, the entertainment industry expert. Such testimony is not admissible under Rule 701. Finally, the admission of this type of lay opinion creates significant risk that the jury will conflate inappropriate with illegal, and therefore raises serious concerns of confusion and unfair prejudice under Rule 403. No opinion on what is or what is not legal could properly be put before the jury because evidence must not embody legal conclusions that encroach upon the court's duty to instruct on the law. They give the example of United States versus Bilzerian. Such opinions are also unfairly prejudicial in suggesting legal conclusions on the ultimate issues. See United States versus Scope. Even a properly instructed jury will struggle to disentangle testimony as to what other witnesses believe is or is not appropriate from the question of whether particular conduct is or is not unlawful. This creates a heightened risk that jurors will render a decision on an improper basis by giving this testimony undue weight. Look, B. Lively should be barred from offering lay opinion that other people thought her cut of the movie was good. Lively should also be precluded from offering lay opinion that various people preferred her cut of Dance with Us to Baldoni's cut. For example, Lively has designated a portion of Hoover's deposition transcript in which Hoover explains that she blah blah blah. Excerpt A, Hoover deposition, blah blah blah. Similarly, Lively has designated a portion of Josh Greenstein's deposition in which Greenstein says blah blah blah. These are just examples that some people involved in the film believed Lively's cut was better than Baldoni's cut has no relevance in any of the issues of the case. It does not make it more or less likely that Lively had a good faith belief that she had suffered illegal harassment. Yeah, it has nothing to do with anything. It does not make it more or less likely that Lively opposed illegal harassment and was retaliated against due to that opposition. These opinions, moreover, are not rationally based on the witness's perception and will not help the jury understand the witness's testimony. Even assuming that this testimony satisfies rules 401 and 701, it should be excluded under Rule 403 as it will waste substantial trial time and confuse the issues. The court should not permit the trial to become a referendum on which cut had more support and from whom. And C. Lively should be barred from offering lay opinion that other people believe she had a good character. Lively should be precluded from offering evidence that other people involved in the making of It Ends With Us believe her to be a talented, good, inspiring person. For example, Slate tells Lively blah 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 blah, or this blah 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 blah, or messages from Hoover telling Lively blah blah. That some people like and admire Lively is inadmissible and is as improper lay opinion under Rule 701. It is also irrelevant and a waste of the jury's time, and so inadmissible under Rules 401, 402, and 403. To the extent Lively would offer examples of her other good acts to show her good character, such evidence is barred under Rule 404b1, which prohibits evidence of other good acts just as it prohibits evidence of other bad acts. See United States versus Dawkins. Follow for part 7. We're getting to the box.